Okay. State's ready.
Yes, sir.
You can announce the case and yourselves for the record, and then we'll let the defense go.
We're here on State of Florida versus Mark Sievers on case number 21, number 15 CF 673B. Present for the state is Assistant State Attorney Hamid Hunter, representing the State Attorney's Office, and Assistant Attorney General Christina Pacheco, representing the state.
Defense.
Good morning, Your Honor. On behalf of Mr. Sievers, Megan Montagno, Jalissa Fontaine, and John Mobianco.
And for the record, Mr. Sievers is present as well. State's ready to proceed.
Yes, Your Honor. However, since it's the defendant's motion.
I know.
Yes.
Defense is ready to proceed.
Yes, Your Honor.
Okay, first witness.
And Your Honor, we would like to invoke the right to release.
Yes, ma'am. State, you need a moment. Defense, you need a moment, either side, to inform your witnesses.
Yes, Your Honor.
Okay.
Well, Judge, the only witnesses present at this moment are members of the bar. They know the drill. I don't know that the.
Well, I don't know if any are outside and will come in. I always see Mr. Masor standing up.
Ms. George is here. Ms.
I'll let you go instruct them anyway. Yes, ma'am. You may proceed and then we'll get going. How's your weekend?
I worked on Saturday.
Oh, did you?
Yeah, that was fun.
Oh, you so you're here for the guest appearance.
I was,
Oh, that's,
although not in court.
oh,
I certainly read it.
It didn't matter, it was on the iPad.
That's what Candace said.
It was an iPad.
glad it wasn't me.
Yeah.
How you doing? All right. Oh, I'm sorry to hear that. I've got some decongestants in the back if you want one. Oh, okay, all right.
Ready to go, Your Honor.
State's ready as well.
Yes, Your Honor.
Okay, first witness.
We will first be calling Miss Kathleen Fitzgeorge.
Yeah.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Morning.
Good morning.
Good morning.
Can I trouble you to state your first and last name?
My name is Kathleen Fitzgeorge.
And Miss Fitzgeorge, you were not on Mr. Mark Sievers' defense team, were you?
No,
Well, then, who did you represent, making you relevant for today?
I represented Jimmy Ray Rogers.
Okay, and Mr. Rogers' relevance to the legal matter we have pending today is, question mark?
He was a defendant in the indictment,
Okay, so co-conspirator with Mr. Mark Sievers.
allegedly.
Okay. Now, were you on Mr. Rogers' case from its inception? Did you come on at some point during its development? Characterize your role generally, please.
I received a call from his family in Missouri and then set up a phone call with Mr. Rogers while he was still in Missouri. So we were on it from the start.
Okay. And I guess as an initial matter, because I'm sure this will become relevant to your responses as we go, has there been a waiver of Mr. Rogers' attorney-client privilege regarding the work you did for him on
Not that I'm aware of, no.
Okay. So in the course of working on Mr. Rogers' case, did you work with Mr. Sievers' defense team?
Yes,
Okay, and with whom did you work? Can you name them, please?
Michael Mummert.
Okay, and was there also Mr. Gregory Masor?
He came on later and didn't really work. He didn't appear very often.
Okay, and I guess did you have an understanding of what his role was within Mr. Sievers' defense team?
Not a full understanding. I mean, he was capital qualified, was my understanding, and he would be present for trial, involved in penalty phase, but also in some of the trial hearings and whatnot, and just the case overall. I'm not sure how you have to be involved in the whole thing to really
Okay.
show
You
up.
mentioned he's capital qualified. Why did you mention that?
Because it's a capital case.
Okay. Is that relevant in the context of any other individuals on Mr. Sievers' defense team?
At the time, Mr. Mummert was not capital qualified to the best of my knowledge.
Okay. And you know between Mr. Mummert and Mr. Masor, who was first chair for Mr. Sievers' trial?
Mr. Mummert was hired by Mr. Sievers. He took the lead certainly with the trial phase.
Okay. And I guess to understand the degree of your insight into the Sievers defense team, did you have an opportunity to work with them kind of in the trenches as the case was being litigated in the pretrial phase?
Yes,
Okay.
extensively.
You said extensively?
Yes.
Okay. Can I trouble you to expand on that? How would you, I guess, characterize it beyond extensive?
Well, I've known Mr. Mummert for many years. I was his supervisor when he was at the public defender's office. And, I've watched him come up through the years and handle a variety of cases. Though he was a good lawyer and, we're friendly. I was friendly with his wife at the time, who was also part of the team. Our investigators that they used, the Olsons, were investigators that I use on different cases as well. So between my team and his team, yes, we were together a lot. All the depositions, we coordinated them, took them all together, and they were extensive. There was a million of them, it seems like.
You mentioned having worked with Mr. Mummert previously. Yes, how are you currently employed?
I'm the chief assistant public defender for the 20th Circuit.
And how long have you been with the public defender's office?
35 years.
And prior to the Rogers Sievers cases, had you tried, I guess, how many capital cases had you tried?
Prior to that case, 4. So at this point, 6 I've handled. I don't know how many, but many of them over the years. I started very young in my career, working on capital murders. And then I went on to run the homicide division.
Okay. In order to get that role, besides trying a number of capital cases in various capacities, are there any other trainings or educational components that you have to complete?
When I began, there was no such thing as being a capital qualified attorney. Someone walked down the aisle of the row where my office was and said, "Hey, we need a skirt on a murder case." And I just raised my hand and said, "Okay." Now there's a lot of different, to be capital qualified, you have to handle so many trials, so many complex cases, so many homicides, trainings. You have to have at least, I think it's 12 credits every 2 years, specifically in capital defense work.
Okay, and when you say so many credits over such a period of time, would those be continuing learning
Yes.
educational requirement credits?
Yes.
Okay, and so you obtain those credits by attending specific death penalty focused seminars?
Yes.
Okay. Now, Were Mr. Rogers' case and Mr. Sievers' cases tried together?
They were not.
Okay. Why not? Or I guess procedurally, why not?
Procedurally, I felt our chances, our best bet was to proceed without them together. This was a massive case. And I kind of felt that the last thing we needed was to sit in a room where Mr. Sievers would be pointing the finger at Curtis Wright, of course, but also Jimmy Rogers. So when it came down to it, we were ready to go and we wanted to get in there, and Mr. Rogers was ready to go. So that's what we did. We just thought it was the best course of action for our client.
Okay. One of the things you mentioned, concern for at whom fingers were being pointed in the course of a trial. Was there anything based on your work with the Sievers defense team that gave you specific concern that could be a component of the trial?
No, just based on my experience. I mean, you have to point the finger somewhere. And Mr. Wright was not his statements. He had given 4 statements and 2 proffers. There was a lot of them. There's a lot of inconsistencies in there that we felt we could capitalize on, but he was no friend to our defense. So then if we were trying them together with Mr. Sievers' case, we just thought, let's just eliminate that aspect of it, Mr. Sievers' aspect, in
Okay.
terms of testifying.
Let me ask you to explain something that I think I heard you say. Mr. Sievers was no friend to our defense. Can you explain that a little bit? To the
Well-
extent that you're able to, with privileges still being in effect.
Well, we felt like we had a pretty solid defense in terms of, excuse me, Mr. Rogers' involvement or lack thereof. And Mr. Rogers and Mr. Sievers didn't really know each other. I mean, they had met, whereas Mr. Wright and Mr. Sievers had been close friends for many, many years. They kind of grew up together. They went to school together. We felt that, and also Mr. Wright was a little bit of a loose cannon in terms of, I mean, here was a man who, in our opinion, who strived to look like Mr. Sievers, who was a little obsessed with him. We didn't know too much about the background in that because we didn't have Mr. Sievers' side of that. So we wanted to really kind of avoid that. Our strategy had been, our client got in a car and came to Florida. He never saw the ocean when he come down. He plugged in his GPS, text on the way with family. He took pictures. He went to the beach. He took presents home for his girlfriend and children.
I'm going to interject, and I apologize for interrupting. So we did see the ocean.
Well, he saw the Gulf of Mexico,
Okay.
Gulf of America.
And ocean. Okay. So I guess I want to make sure I understand it. Concerns for any potential finger pointing from the Sievers camp towards your client was based on your experience regarding things that can happen in co-defendant trials rather than any concrete specific information you'd received from Mr. Sievers' defense team.
Correct.
Okay. Now, you characterized Mr. Mummert's work and overall role in the case as, I guess, maybe you didn't, and I'll ask you to do that now. How would you characterize it?
Very thorough.
Okay. And you'd indicate that he wasn't at the time death qualified. Did you observe anything that in your professional perspective was, an indicator of that when you were watching him work? Was there anything you said, oh, I wouldn't have done that?
No, nothing.
Okay. Would you say the same thing about Mr. Missouri?
No.
Okay. I guess How would you characterize Greg Missouri's influence on how the respective cases developed?
I don't think he had much influence. He was largely not present. I don't think he showed up at one deposition. We had a lot of hearings, motions, court events. I mean, maybe a handful of times then, but at most. So I didn't have any real relationship with him. So
Okay. Yes, in the course of the extensive collaboration with Mr. Mummert, you never had an opportunity to also collaborate with Mr. Missouri?
I didn't collaborate with him. No.
Okay. And I imagine during Mr. Rogers' trial, you weren't picking out every face in the audience, but do you recall whether or not Mr. Mummert attended any of the days of trial for Mr. Rogers?
He did attend. Some, many. Yeah.
Can you recall whether or not Mr. Missouri attended?
I don't recall. I don't recall him being there, or I don't recall looking for him. He wasn't someone I interacted with on the case at all.
Okay, so I guess let me make sure that that response is accurately characterized. You weren't necessarily looking for him, but to the extent that you did any looking, you did not see Mr. Missouri.
Correct. I saw a lot of the rest of Mr. Sievers' team in the courtroom.
Okay. Hold on one moment, please. Those are my questions for now. Thank you.
Great.
Morning, Ms. Fitzgeorge.
Morning, Mr. Hunter. This is unusual, huh?
Different look from up there, isn't it?
Yes, it is. I don't think I like it.
It definitely gives us some perspective as trial lawyers. So, Ms. Fitzgeorge, I didn't hear defense ask you, how many death penalty cases have you tried?
I've tried 6.
And these
Now.
were
So as of this year,
these were cases where death was a possible outcome of the trial.
yes. On at least one of them, death was, well, you were there, death was waived, very close to trial. So, but it had been a factor throughout. So,
One in Hendry County.
yes.
And after a trial, how many of those cases ended in a sentence of less than death, including the one we had in Hendry County?
All but one.
All but one. Congratulations.
Thank you.
So it's safe to say Mr. Mummert was well-trained when he was an assistant public defender.
I think so.
Mr. Mummert was trained on the fundamentals of criminal defense law.
Yes, we worked together when he was on the Judge Reese track that I ran quite a few years ago. So,
And is it safe to say that many of the pretrial hearings that happened in the Rogers and Sievers cases all happened at the same time in court?
they did, yes.
Were you present for the hearings that were conducted in this courtroom regarding Mr. Mummert's and Mr. Fega's qualifications?
Yes,
And you recall Mr. Sievers waived no qualifications. You recall that?
I remember there was a question by the judge asking Mr. Mummert, are you capital qualified? No. Well, do you have someone? Do you talk to someone? He said, well, Ms. Fitzgeorge. So I do recall that.
Do you recall the court offering Mr. Sievers death qualified counsel?
I do.
And Mr. Sievers opted to stay with Mr. Mummert. Isn't that correct?
That's correct.
And is it safe to say that you don't know what Mr. Missouri did in preparation of their defense
Correct.
or mitigation?
Correct.
Were you present for the the penalty phase of the Sievers trial?
Some of it, I don't know, I don't recall that I was here for all of it.
And in fact, Mr. Masori led the penalty phase, didn't he?
He did.
And we talked earlier about your decision, which was kind of also I'll say a 10th hour decision in the case to move to sever Mr. Rogers from Mr. Sievers.
Correct,
That was a tactical decision, right?
correct.
You made a reasoned and legal decision to protect your client.
Yes,
And the court, you said earlier that you hadn't yet received a waiver, despite the fact that your team not only defeated the death penalty for Mr. Rogers, but also secured convictions on lesser counts. Are you aware that he filed a 3850?
Objection, Your Honor, relevant.
Overruled.
I did see one in court file, yes.
And he's alleging ineffective assistance of counsel on part 5 of his claim,
Sure.
despite what you did for him.
Mhm.
If ordered to waive privilege in that hearing, will you waive then?
I would.
Mr. Mummert's preparation in this case was thorough.
Yes.
You wouldn't have prepared any differently.
No, I mean, you always want more time. I think we filed a last minute motion for a continuance each time. We sat for trial twice. There's always more to do. The last place you want to be on a death penalty case is in front of a jury, frankly.
And if you were Mr. Masori, you would have been present more often.
I would be, yes.
You also didn't file for a change of venue in Mr. Rogers' case, did you?
No, did not.
Now, at some point after Mr. Rogers' trial, one of the issues that's here before the court is a letter that Mr. Rogers sent to, I believe, Mr. Sievers' mom
Yes.
In the end of December of 2020. I think we were still in trial. We might have still been in the penalty phase of this case. Mr. Rogers in his letter told Mrs. Sievers some things.
Objection, Your Honor, this is getting outside the scope of direct.
State.
Judge, well, it is a little bit beyond the scope of direct, but it has to do with her expertise. It has to do about whether or not this evidence is truly newly discovered evidence.
Sustained.
And despite the fact that you felt that there was some antagonism between your defenses, not the defense teams, but your defenses may have been antagonistic to one another, you didn't have any problems conducting depositions and doing hearings with Mr. Mummert and his team.
No, not at all.
And in fact, Mr. Mummert had a team, right?
He did. A team of non-lawyers.
Correct. Investigators, as well as a legal assistant and whoever else he had sitting back there with him.
Yes.
Thank you.
Any redirect?
Briefly, Your Honor, thank you.
Yes, sir.
Whether originally on direct or through cross, you'd indicated that Mr. Masori could have been more present. Is that one kind of accurate reflection of what you said?
Objection, counsel's mischaracterizing the testimony on direct and on cross.
Sustained.
Based on your observations of Miss Sori's relative level of activity on the case as you were able to observe it, could Mr. Missouri have been more present?
I think the answer would be that if I was him, I would have been present.
Why do you say that?
I would, if I'm counsel on a case, I'm gonna move heaven and earth if someone's life is on the line to be present.
Okay. And I believe you'd indicated that Mr. Mummert had kind of an entire defense team working with him. Is that accurate?
He had what was then his wife who ran his office. She would help organize the massive amounts of discovery. There was a lot of organizational aspects to it. And another assistant, and then the two investigators. So,
Can you recall whether or not Mr. Mummert had kind of consulted with you regarding, what is a satisfactory makeup of a defense team in such a trial?
I don't. I will add that our team, we had a paralegal and an intern, but our team was made up of lawyers in an effort to get other lawyers capital qualified. So normally we would have 2 people on a team. We had 4 because of the necessity to become capital qualified.
Why do you make that point?
Because going to trial with 4, or as in my last trial, 5 lawyers probably isn't a great idea.
All right. One moment, please.
Yes, sir.
All right. That will do it for me. Thank you, Your Honor. And thank you, Ms.
State.
Fitzgeorge.
Just one question. Regarding Mr. Mummert's qualifications, Mr. Sievers has the right to hire the attorney of his choice, right?
Yes.
That's his right to counsel, correct?
Yes,
And that is something that we should respect.
yes.
Thank you.
Is this witness to be released or retained? State? Agree?
Agreed.
Thank you, Ms.
Am I
Fitzgeorge.
free to sit in the courtroom then?
Absolutely. You've been released. Next witness.
Michael Mummert.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Mummert.
Good morning.
How are you doing today?
I'm doing well.
Can you please state and spell your name for the record?
Michael Mummert, Michael, last name Mummert.
And how are you currently employed?
I am the owner and principal attorney at Mummert Law Firm.
How long have you owned your own law practice?
It's 2018.
Okay. I'm sorry, 2018.
18.
Okay. What is your main area of practice in your law firm?
Currently, it's family law.
Okay. And how long have you been a member of the Florida Bar?
Since 2005.
You've been practicing for 20 years?
Yes.
Going back in time, can I ask where you, after passing the Florida Bar and becoming a licensed attorney, where did you first practice law?
First, briefly with Coleman Hazard and Taylor, a civil law firm, and then I went to the public defender's office, which was where I spent the next 8 years.
And was that the local public defender's office?
Yes,
Here?
I did about a year and a half here in Fort Myers and the remainder of the time in Collier County.
Is that all within the 20th Circuit?
It's all within the 20 county.
What types of criminal cases did you handle at the PD's office?
Everything from misdemeanor DUIs. I had a very brief stint in juvenile, and I handled all manner of felonies, including felony murder. So, yeah,
Did you handle any capital cases while employed at the PD's office?
I did not handle any capital cases.
And what year did you leave the PD's office?
2013.
And where did you go after the PD's office and prior to starting your own firm?
I went to the Fega Law Group. Tony Fega, who's now deceased, owned Fega Law Group, so I went and worked with him.
Were you still practicing criminal law with Mr. Fega, or is that when you started your pivot to family law?
That's when I started my pivot to family law, but I was still actively practicing criminal defense.
Would you say at the time of either when you started with Mr. Fega to at the time of when you took on Mr. Sievers' case 2015, 2016, were you still handling criminal cases or were you doing a majority of family law?
I was still handling criminal cases.
What types of criminal cases were you handling?
Misdemeanors. I believe I had a trafficking case, conspiracy to traffic case. At that time, I believe I had. I had taken on a couple sex crimes, really just kind of all over the place, but still generally, misdemeanor felonies.
How many jury trials would you say you've completed?
At present, I've had well over 40 felony jury trials, and as far as misdemeanor jury trials, I couldn't tell you.
Just want to fast forward to your involvement with Mr. Sievers' case. How did you get involved with this case?
So Mr. Fega asked me to go and talk to Mark about the dependency case.
Okay, so the first interaction was not involving the criminal case at all?
No, it was, I was sent to talk about the dependency case. The department had gotten involved, and then we ended up talking about the criminal case, and that's when we were retained.
Okay, and would your involvement on the dependency case because of your family law kind of pivot at that time?
Yes.
And was this a capital case at that point?
No, it was a second degree.
At what point did it become a capital case?
When the indictment came down, I don't remember the exact day. I do remember hearing that the indictment came down, and I immediately went. It was like 8 o'clock at night, and I went to the jail and I talked to Mark about it.
Was Mr. Sievers your first capital case?
Yes.
Do you still do capital cases?
I've done one since State versus Adam Souls. It was capital, but it was non-death.
Okay. Do you know if there are specialized CLEs that you would have to do in order to do capital cases?
Yes.
Have you attended those?
Yes.
Do you recall when you first attended them?
Not with much specificity. I know I did. It was either Death is Different. I posted the CLE. It's part of my Florida bar, but I did attend at least one death penalty CLE during the pendency of Mr. Sievers' case.
Would that have been before the trial?
Yes.
Do you recall at all how close in time or how far from the trial?
I don't, but it's like I said, it's I reported it as one of my CLEs for my reporting requirement to the Florida bar. So it's been recorded.
And at those seminars, did they have presentations on the importance of hiring and using experts to craft a defense?
Somewhat, mostly from my memory, it was the importance of jury selection and mitigation. And so mitigation obviously does require experts, but yes,
Okay, so from your recollection, the main focus was jury selection and mitigation.
yes.
Do you recall any sessions on crime scene experts or anything of the sort?
I don't.
You get one moment, Your Honor.
Yes, ma'am.
And Mr. Mummert, if it doesn't bother you, would you be able to speak up just a little louder so Mr. Sievers can hear?
Sure.
Thank you. Now, okay. And just to reiterate, you said you didn't recall any sessions on a defense or experts for crime scene.
No, so the Mr. Sievers trial was approximately 6 years ago. This would have been further back in time than that. So I don't have a lot of specific recollection about exactly what was presented, other than they spent a significant amount of time on jury selection.
Okay. Initially, what was your role in Mr. Sievers' case?
And well, initially I was just the attorney who was going to primarily handle the case. I don't want to speak on Mr. Fega's experience, but I know that I had more recent trial experience than Mr. Fega. And so it was contemplated that I would be the one who would be basically trying the case.
You just mentioned you had more recent experience than Mr. Fega. What was Mr. Fega primarily practicing at that point?
He was primarily doing transactional real estate. He had a general practice, so he did some family law and civil litigation, but day in, day out, he was doing real estate transactions.
Did he have any criminal experience?
Yes, he did.
Now, when the state filed the notice to seek death, were there any conversations, either internally or externally, to come off of Mr. Sievers' case?
I don't recall. And by conversations, do you mean with Mr. Sievers, or do you mean within the firm?
Either internally or externally.
I really don't recall. I remember getting the indictment, going to see Mr. Sievers. We talked about it, and at that time when the indictment came down, I had a pretty good idea that a notice to seek death would be imminent. I don't believe that we had that conversation, but again, it's been many years since that indictment came down.
Okay. Were there any conversations to bring on a death qualified attorney?
Yes.
Was one brought on?
Yes.
Who was that person?
Ultimately, it was Mr. Attorney Gregory Masor.
And how did he come on the case?
I believe Greg reached out to us and offered, and of course we were more than happy to accept the help.
Was there any kind of vetting or interview process?
Again, it was a long time ago. I'm I'm not, I don't have a lot of memory. I do remember over the years having several conversations with Mr. Masor. And, you know, I think we were able to effectively work together.
And at some point, when Mr. Masor came on the case, was Mr. Fega still on the case, or had he passed on at this point?
I don't remember. I'm sorry. I do not remember. I know Mr. Fega passed away in October of 2018, I believe. But I don't remember when Mr. Masor came on the case.
Okay. Prior to Mr. Fega passing away, how were the roles divided in this case? Were you responsible for one thing? Was he responsible for another, or did you just take all of it?
By he, do you mean Mr. Fega?
Mr. Fega.
No, I was primarily responsible for everything. However, you know, Mr. Fega at that time, still being my boss, ultimately had some veto power, but I was the one who ultimately, it was my case, so ultimately it's my responsibility.
So were you the one doing all the research,
Yes,
reviewing discovery,
yes,
looking into any experts, if any, to contact?
yes.
And you said you were unsure if Mr. Masor was on the case at this point.
Yes, and I'm sure he entered a notice of appearance of co-counsel, so that would probably be the best evidence of when he came on board.
Okay. After Mr. Fega died, how were the duties divided?
It was May.
What was Mr. Masor in charge of?
So Mr. Masor was doing the mitigation. So as I said, I had a significant amount of trial experience, including a murder case. However, I had never done mitigation. So we believed it was best to have the person who's already done the mitigation do the mitigation in this point, just for familiarity purposes.
Did you give any direction to Mr. Masor, or did you just say, go do the mitigation and run with it?
No, we worked together on it. You know, and I'd like to think that I had some input, just the same way that Mr. Masor had input on the guilt and innocence phase.
What input did you have on mitigation?
So one of the decisions we had to make was hiring a mitigation expert. Believe we landed on oh God, his name is escaping me right now. I do apologize. Jeff Giordano. Jeff Giordano was our mitigation specialist, and you know, we talked to Jeff, and we agreed that Jeff was ultimately a good person to do this job after we had several people who weren't.
So he was not the first mitigation specialist?
He was not.
How many people preceded him?
2.
Do you recall how the time in relation to trial beginning that Mr. Giordano was brought onto the case?
Again, not with a lot of specificity. So I know he was our 3rd mitigation specialist, but again, the exact when I could not tell you.
Okay. You also mentioned that Mr. Masor had some input into the guilt phase portion.
Yes.
Were you mainly in charge of guilt phase?
I was.
Who made the ultimate decision as it related to guilt phase?
That would be me.
And what kind of input or suggestions was Mr. Masor given?
So during jury selection, Mr. Masor and I had discussed every juror, and his input was invaluable. It's always nice to have another lawyer to bounce ideas off of. Okay, did you notice anything about this potential juror that maybe I missed? So in that respect, and I do remember, certain witnesses having conversations. I mean, brief conversations at the table. So yes, Mr. Massour is quite helpful.
Was his role limited to jury selection?
No. Again, we discuss witnesses, and this was a long time ago. I apologize.
Okay.
I believe we discuss some witnesses, and I think he had some input even into my closing argument. But again, this was so long ago.
Do you recall if he assisted prepping any witnesses or helping with cross-examinations at all?
No, I did all the cross examinations.
Who participated in depositions?
Mainly me.
Do you recall if Mr. Massour went to any of them?
I do not recall.
Now, this case was initially tried with Mr. Rogers' case.
Yes.
How was that working relationship with Mr. Rogers' team?
I'd like to think we had a good working relationship. Ms. Fitzgeorge, who was the lead attorney on Mr. Rogers' team, she was actually my supervisor while I was at the public defender's office. And she's certainly someone with whom I respect and have great admiration for. And she was very helpful, knowing that, yes, this was my first capital case, giving me advice, and I will be eternally grateful for her assistance.
You said she would give you some advice. Do you recall if there was a specific area you would reach out to her about?
Just about. I know she gave me advice. You should probably go to this CLE. I think it was might have been Death is Different. But I certainly followed her lead in depositions. And we had, over those years, we had a lot of conversations about this case.
Would you find Ms. Fitzgeorge took the lead in depositions a majority of the time?
The majority of the time, yes.
Okay. Do you recall if there were any conversations, if Mr. Rogers had any helpful, any information that could either help or hurt Mr. Sievers?
I do not recall.
Do you recall if there were any shared theories?
Oh, yes. Yes, we definitely had some shared theories. But our cases were very different.
How so?
So, Mr. Sievers' case was more about the conspiracy, about the prepaid phones, about the communication with Mr. Wright, versus Ms. Fitzgeorge's case, which had a lot more to do with forensic evidence, crime scene, the jumpsuits, where the jumpsuits were deposited, the cell phone tracking records, because our clients were 1,000 miles away when the murder occurred.
You just kind of made a line between kind of like forensics with Mr. Rogers' cases and not forensics with Mr. Sievers' case.
Yes.
Did you find forensics more so irrelevant for Mr. Sievers?
Yes and no. So in the strictest legal sense, it was irrelevant what actually happened in the house. If we look at 401 and 403, being that it was my opinion, and judge disagreed with me, that the prejudicial value of most of the forensic evidence outweighed the probative value. I mean, this was horrific, this was gory, and our case really just depended on whether there was a conspiracy and whether a series of phone calls had happened. We didn't need the records of how the tow truck towed the car from wherever the enterprise was down to Florida. That wasn't really relevant. How the jumpsuit ended up at the side of the road, that wasn't really relevant. However, I understand that they were co-defendants. This was all evidence in the same set of charges, and so in that respect, yes. Although I personally believe that the prejudicial value outweighed the probative value, and therefore, a lot of this evidence I felt really put Mr. Sievers in the position of having the jury judge him more as a person rather than for what he did. And, one of the jury instructions is you should not decide this case if you are angry at anyone or feel sorry for anyone. And I believe a lot of the evidence that came in did exactly that. And so it was our position that in Mr. Sievers' case in chief, a lot of the evidence was kind of extraneous, but it got in.
Okay. Kind of going off of that line of thinking, did you find that experts had a role in this case? Or did you find a role for experts in this case?
Yes, Ms. Lyons was our expert witness who testified about she was the Sievers estate planning attorney, and she actually was very helpful, and that the jury found that the murder was not committed for pecuniary gain. And so, yes, Ms. Lyons was invaluable in our defense. But as far as our theory of defense, she was the expert who was the most pertinent to our side of the case.
Do you recall if you consulted with any other experts?
Yes. I know we consulted with, I believe it was Dr. Underwood. Dr. Underwood met with Mark on a couple occasions, ran a litany of psychological tests. I believe it was a MMPI. There were other cases where he was looking for essentially mitigation evidence.
So that would have been a mitigation.
That would have been a mitigation expert. I don't believe Mr. Underwood ever generated a written report. I'm unsure of that, but I know he was deposed, and the state had an opportunity to kind of get his findings.
Do you recall any experts as it more so relates to guilt phase?
Other than Ms. Lyons, I don't.
Do you recall if you spoke to a crime scene expert?
I do not.
Would the name J.D. Thomas sound familiar?
It does. And again, I may have spoken to Mr. Thomas, but again, I don't recall that conversation with any distinct recollection.
Okay. Moving forward to kind of the pretrial portion, were you aware of the media attention this case garnered?
Yes.
Did you follow the news?
No, it followed me. I would get people, oh, I saw you on the news. Great. Just like I'm sure I'm going to hear about this tonight and tomorrow.
Did you ever consider filing a motion to change venue?
We did.
Was
And
one ultimately filed?
no,
Why not?
because ultimately I made that decision. And so when you change venue, you don't get a say to where the venue actually lands. So we could have ended up in Collier, Polk County, Hendry, Glades. We didn't really get a choice. And when you don't get a choice, again, you're dealing with the unknown. And had we ended up in, say, Glades County, this would have been everywhere. We could not have gotten a jury in a Glades County. Had we ended up in Collier County, we would have actually ended up with a more conservative demographic. And so we had these conversations, and ultimately I made a strategic decision to not change venue.
Okay. Do you recall if you researched or considered filing any other motions pre-trial?
I mean, I filed a bunch of motions. I filed motions in limine. I mean, can you be a little more specific, please?
I'll come back to that question. Okay, one moment, Your Honor.
Yes, ma'am.
Just want to fast forward to Mr. Curtis Wainwright. What was Mr. Wright's role in this case?
So it is my opinion that Mr. Wright was the only person swinging the hammer. He was the murderer. And that was based on the some of the crescent-shaped bruises and lacerations on Miss Sievers' skull were all the same size. So he was also the government's star witness, and he got an advantageous plea deal in exchange for his testimony.
And what was your plan for dealing with Mr. Wright, or putting forth your theory of his involvement?
Well, my theory was basically that he was willing to lie in exchange for the best possible outcome. And when you look at his testimony, first time the police talked to him, he said, I wasn't there. And then the next time, okay, I was there, but I didn't go in the house. And then it was, okay, I was in the house, but I wasn't in the room. And then it was okay, I was in the room, but I didn't swing the hammer. And then it was, okay, I was in the room and I swung the hammer maybe once or twice, but that was it. And so we had multiple inconsistencies, and there's no way to reconcile those inconsistencies to say that it was mistaken. No, these were lies. These were lies. And even I believe in his proffer, Mr. Hunter said, "You are not being truthful." So essentially, one of the jury instructions is, again, you should consider the truthfulness of the witness's statement. Specifically looking at, did the witness ever make a prior statement that was inconsistent? And in this case, Mr. Wright absolutely did. And it was very clear that he made these prior inconsistent statements, these lies, in exchange for an advantageous plea deal. And that was not rebutted.
Do you recall if you considered consulting with an expert to advance your theory?
That he lied, that it was recorded. I mean, there was no need for an expert. This was, he gave 5 separate inconsistent statements that one of them could not be true if the other one was. There was no need for an expert. These were lies. Everyone knew they were lies. And yet I cannot see how an expert would say, oh yes, when he says he was not in the house and he said, oh, I hit Dr. Sievers with a hammer. There's no way for both of those statements to be true.
Okay. Did you have any desire to speak with Mr. Rogers?
I don't know. So I learned after the trial that Mr. Rogers had changed his story. I learned after the trial that Ms. Shoemaker had changed her story. And obviously that prior to trial, that would have been helpful. But I hadn't. Yes, my short answer is yes. I would have liked to have spoken to Mr. Rogers. However, he was represented by counsel, and in order to speak to him, I would have to get Ms. Fitzgeorge to agree to allow me to.
Did you make any attempts to do so?
I did not. I did not, because I know that she, her client was facing the death penalty the same way as my client, and Ms. Fitzgeorge is a fierce advocate for her clients.
And then lastly, do you recall how records were shared in this case between your office and?
Okay, so we originally, when this case was going on, I'll fast forward. Currently, records are shared from the state to defense. There's a kind of a portal, and you download it. If it's a bigger file, then there's a Axon evidence that you can download these files. And if it's really big, you bring a big flash drive to the state and they give it to you. In this case, we got CDs. It was long enough ago where people were still using CDs. And so I had a big file of CDs. And so at the time, my office was at Winkler and Evans, and we had an entire room at the office that was just dedicated to Mr. Sievers' case. That was all that was in the room. We had trial clothes in there, some paper evidence, but that was the room. And so I don't believe we would have emailed evidence. A lot of this evidence, especially, I remember there were some paper medical records that the court ordered to us to basically not disclose to anyone. Those have since been destroyed.
Let me ask a better, more generalized question. Was all the evidence mainly stored in your office?
Yes.
And then if somebody needed to look at it, would they have had to come to your office?
Yes.
Okay. Do you recall what your email was when you were with Vega Law?
I had a couple, mmummert@fegalaw.com, and then mmummert@mslawpllc.com.
Do you recall what Jennifer Mummert's email was?
It would have been probably J Wood, which was her maiden name. I don't know if she ever got a J Mummert. It's possible.
Okay, I'll pass witness.
State.
Good morning.
Good morning.
You testified that you've been practicing law since 2025 or 2005, is that right? And you worked at the public defender's office for 8 years.
Yes,
Miss Fitzgeorge was your supervisor.
she was.
You learned a lot from her.
I did.
And 7 of those years at the public defender's office were spent in the felony division, is that correct?
Yes.
And I think during direct, you described your trial experience as significant.
Yes.
You had well over 30 felony jury trials by the time you left.
Yes.
And then you went into private practice, right?
I did.
You talked about the Fega law firm and how you came about to represent Mr. Sievers, but your firm was actually representing Mr. Sievers in a number of different actions. Is that correct?
Yes, we had his probate. There was the wrongful death, the felony, the dependency. I think that's 5.
And so all of those separate cases, your law firm was involved with representing Mr. Sievers.
That's right.
And that included his murder case.
Yes.
What we're here for today. And you primarily were responsible for handling the criminal case, correct?
That's right.
Is it fair to say that you had a good rapport with Mr. Sievers?
I'd like to think so.
You visited him in jail weekly?
I mean, not every week, but pretty close. Generally, on most Sundays were the days where we would go and we'd see Mr. Sievers in the jail and spend a couple hours with him.
Okay, so these weren't short visits.
No, they were not.
You said they would span for several hours at a time.
Generally, yes.
And away from your visits at the jail, you spent a lot of time working on Mr. Sievers' case.
I can't even begin to calculate how many hours. I've between court, research, prep, depositions. Yes.
Mr. Sievers wanted you to represent him, is that correct?
Yes.
And he knew that you were not death qualified.
Yes, that was no secret.
Okay, and there was actually a court hearing about that, right?
There was.
He was explained the benefit of having a death qualified attorney,
He was.
but he had retained your firm and had you representing him.
Yes.
Despite the knowledge of the protections in place of having a death qualified attorney, he wanted to proceed with you as his counsel of choice.
He did.
And he wanted you to represent him so much that he didn't mind that you were not death qualified.
That's right.
While you were not death qualified, you felt that you had the knowledge, experience, and ability to represent him.
I did.
You would not have represented him had you thought that you would not be able to provide competent representation. Is that correct?
That's right.
And you touched on the decision ultimately not to change venue in this case or move for a change of venue.
Yes.
Is that something that you went back and forth on?
It is. It is. And I actually went so far as to draft the motion. I believe I started looking for, you need 2 witnesses to testify that they've heard of the case. And They're familiar with it. So I know I had a couple affidavits drafted, but ultimately this is one of those things I just went back and forth on. And ultimately, when I thought about it, it made the most sense to me. I mean, everything that's unknown is a calculated risk. And to me, leaving venue here in Lee County, Florida, I believe benefited Mark the most.
So that was a strategic decision that you made
Yes,
after weighing all of your options.
yes.
And you didn't represent Jimmy Rogers, right?
At no time did I represent Mr. Rogers.
But you are aware that his trial was also local.
Yes.
You talked about attending a CLE seminar. I believe it was
Life over death. Yes,
Life Over
that's it.
Death.
Thank you. Yes.
And that you learned about jury selection during that seminar.
Yes.
Did you follow that paradigm that you learned during the seminar and apply that to Mr. Sievers' case?
I did.
And you also had Mr. Masor assisting you during jury selection.
Yes, I did.
You two spoke about every potential juror.
Every last one.
Did you ever feel like you needed to hire a jury selection expert to assist you?
No.
Had you felt that you needed an expert, would you have sought one out?
If I felt like one was necessary, I would have.
Okay, and Mr. Masor did handle the penalty phase aspect of the case that was in front of the jury, right?
Yes, I did the Spencer hearing, but he did the jury portion.
Okay, so you did the Spencer hearing that was part of the penalty phase in front of the judge.
Yes,
So you were still involved in the penalty phase preparations.
I was.
You spoke with a different mitigation specialist.
Yes, 2 prior.
Okay, and then you ultimately retained a
Mr.
third one.
Giordano.
You mentioned that you had a room in the office that was dedicated entirely to Mr. Sievers' case. Is that correct?
That's right.
Did you make that room available to your mitigation specialist?
100% yes.
You gave them access to that room if they needed to
Yes.
have to get any of the materials.
Yes.
And you mentioned that you had Mr. Sievers evaluated by Dr. Underwood.
Yes.
You were present for those evaluations and meetings?
I do not believe that I was. So I do recall one of the diagnostic tools was the MMPI, which is the Massachusetts Multiphasic Personality Inventory. That has close to 1,000 questions that you write down. And watching Mr. Sievers fill out the MMPI, I think is going to be more helpful to a psychologist than a criminal defense attorney.
Okay. Do you recall attending any of the meetings between Dr. Underwood and Mr. Sievers?
I believe I was there for their initial meeting. You know, I want to just make sure that if I'm introducing someone to Mark, that that there's good chemistry there. That you know, I want to make sure it's a good fit. That they're going to work effectively together.
So is it fair to say you didn't actually observe him, Mr. Sievers, filling out all the questionnaires, but you did take part in some of the process of the evaluation?
Yes.
Okay, and ultimately, Dr. Underwood did not diagnose Mr. Sievers with anything that would have been helpful in his mitigation phase.
No. So for mitigation things that would have been helpful, schizophrenia, bipolar type 2, you know, things like that nature that, okay, you know, Even if the jury were to find someone guilty, okay, well, maybe this is something that due to, a mental illness, they were, this person did not really have as much of the capacity to appreciate what they were doing. But no, there was none of that.
Is that the reason why ultimately Dr. Underwood wasn't called to testify in the case?
Yes, we don't need an expert to say that Mr. Sievers has no mental health issues.
Fair enough. And there was a mention on direct of a expert named JD Thomas,
Yes,
but you don't really recall the interaction.
I really don't.
Okay.
I really don't.
You had phrased the theory of the case and explained that there was a lot of extraneous evidence during the trial that you did not feel like related directly to your client, Mr. Sievers.
Yes.
If you had a crime scene expert testify, do you feel that it could have potentially fallen into the aspect of being extraneous rather than helping your client?
I do. Just at a certain point, you hit diminishing returns. And I cannot say in good conscience that, okay, a crime scene expert would have been necessarily very helpful to Mr. Sievers' portion of the case. Our theory has always been that there was no conspiracy, not that there was no murder, not even that Mr. Wright did not commit the murder, just that there was no conspiracy. Our theory of the case is that if it was designed to look like a home invasion robbery and there was $30,000 in cash in the house, why wasn't that taken? If the purpose of this is a murder for hire, why was the murder carried out in the least efficient way possible? And it looked more like anger and rage than somebody who came to take life very efficiently and escape without notice. There were the inconsistencies with the state's theory of the case that this was a murder for hire. And I still believe Mr. Sievers is innocent. And I'll go to my grave believing that. It just didn't make sense. That and the fact that Curtis Wright was a known liar. And the jury knew it. And yet I think some of the photos of Dr. Sievers were some of the worst photos I've ever seen. And I think at the end of the day, this is just me speculating here, that the jury was moved to either anger or sympathy over the manner in which Dr. Sievers was murdered.
If I may just have a moment.
Yes, ma'am.
You mentioned the what you refer to as gruesome autopsy photos and crime scene photos. You actually attempted to get those excluded from evidence, right?
Yes.
And you were not successful with that.
I was not. So it was my theory. There was no question that she was dead. There was no question that she was murdered. There was no question about the manner in which she was murdered. The question was Mr. Sievers, was he the mastermind? Was did he orchestrate this? And ultimately the gruesome autopsy photos didn't advance the state's theory that yes, he was the one who orchestrated that. If there was some evidence that, hey, Mr. Sievers says, hey, I want you to go and murder my wife with a hammer, and that's how it happened. Okay, I can see the relevance there. But it wasn't. And so the sole purpose of the gruesome crime scene photos and autopsy photos was to prejudice the jury against my client.
Rogers never offered to testify in Sievers' case. Is that correct?
That's correct. Well, he may have after the fact. I don't know if he has since, but at the time of Mr. Sievers' trial, he had not.
Okay. So when you were preparing for the trial, you never heard from either Mr. Rogers or Miss Fitzgeorge that, hey, Mr. Rogers is willing to testify in an effort to help Mr. Sievers.
No, I would have remembered that, and I would have taken Miss Fitzgeorge up on that.
Okay. One of your themes was that Dr. Sievers was worth more alive than she was dead. Is that correct?
100% yes.
And you tried to discredit the state's murder for hire theory.
Yes.
You tried to show that the murder was not committed for pecuniary gain.
And I was successful in that.
Yes, the jury ultimately did not find that aggravator, correct?
Yes.
When I asked you about the time that you spent on Mark Sievers' case, you said you couldn't even begin to estimate. I mean, if you had to, how many hours do you think you spent on his case?
I mean, given everything, I mean, over 1,000 hours, and it's not even really close. Just looking at the evidence, preparing, going to court, seeing Mr. Sievers in the jail. It was a very, very time intensive case.
Okay. Did you also have Mr. Al Olson working with you?
I did.
And he was part of your defense team?
We had Mr. Olson as our private investigator. Yes.
Okay. And does a Mr. Tom Matthews ring a bell?
Yes. Mr. Matthews was, I believe, an accountant.
Okay. And he would have been someone that you possibly consulted with?
I believe we did, just to kind of look over the Sievers finances, and everything indicated that the Sievers family was doing well financially. It looked like they were more spenders than savers, but they lived a nice lifestyle. They did the things they wanted to do. They bought the things that they wanted to buy. And as far as I could tell, all of their bills were getting paid, and the Sievers family was not in any dire financial trouble.
You mentioned that you felt that Mr. Wright was infatuated, or I'm sorry. No, I'm sorry, did you mention that Mr. Wright was infatuated with Mr. Sievers?
I believed he was, yes.
Okay. Sorry about that. I couldn't remember at the time. Okay. So why did you believe that he was infatuated with Mr. Sievers?
So there were some text messages that just heterosexual friends don't send to each other. Like little pet names and things like that. That just, it kind of struck me as this may have been a relationship that, maybe Mr. Mr. Wright may have wanted something more out of the relationship.
Sievers never admitted to you that he had a relationship with Mr. Wright, though,
He
correct?
did not, no.
Okay. And are you aware that he actually denied having a relationship during his evaluation with Dr. Underwood?
Yes.
But you were aware that there were potentially some allegations that there was a relationship there.
It's just the text messages, just there were some text messages about hey there sunshine, is it up, referring to like morning erections. It just just kind of bizarre.
Did you choose not to focus on that information and have the jury hear that information?
I did.
And why was that?
Well, a couple reasons. One, it was my belief that Mr. Sievers wanted to effectuate his constitutional right to remain silent. And for me to really get into that, that would have required Mr. Sievers' testimony. Also, I don't know how a jury is going to take that evidence. And if you're not sure, and you're the defense, and you know that the state carries the burden of proof, then you're not going to introduce a new element into the trial that, if there are people on the jury who are homophobic, maybe they hold that against Mark. Maybe they judge Mark based on homophobia and not on the facts and the law.
In addition to possibly having a bias against being homophobic, would it potentially introduce a motive that may not have existed in their minds before?
It absolutely could have. It absolutely could have. And so it just, it ultimately, it didn't make sense to just introduce something that I don't know how the jury's going to take it, and I don't know if it could actually make my case worse.
So that was a strategic decision by you not to introduce that evidence and proceed on a theme of that sort,
Yes,
that there was a sexual relationship.
yes,
All right. During the deposition a few weeks ago, you cried. Is that correct?
yes. Thank you.
That wasn't the first time that you cried about this case, was it?
No.
You care very much about Mr. Sievers,
I do.
and you care about his case.
I do.
You followed what was going on with his direct appeal.
Yes.
You watched his Florida Supreme Court argument.
No, I actually believe I had court at that time that conflicted with that.
You didn't travel to Tallahassee to?
No.
Okay. But you did
I followed it.
follow his case. And you feel that you did everything you can to represent him adequately
I do. I also feel like I failed.
because you didn't get the result that you were hoping for.
Yes.
If I may just have a moment, Your Honor.
Yes, ma'am.
I'm ready, Your Honor. That's
You may
okay.
proceed.
Thank you, Your Honor. There was actually a written stipulation between the defense and the state to not go into the sexual or alleged sexual relationship between Mr. Wright and Mr. Sievers. Is that correct?
Believe so, yes.
Okay. And going back to when the state initially sought to seek the death penalty in this case, you actually moved to get the indictment dismissed. Is that right?
I did.
Okay. I have no further questions, Your Honor.
Defense.
Yes, briefly.
On cross, you mentioned that you had never heard from Mr. Rogers or Ms. Fitzgeorge that Jimmy had wanted to testify.
That's right.
And you stated you never represented Mr. Rogers.
Yes.
Did you have a release from Mr. Rogers?
Like a release of,
Information?
no,
On direct, you stated that at some point Mr. Rogers had changed his story. How are you aware of that?
I believe I saw something in the news.
Okay, so that's from extraneous information.
Yes,
Did you ever order the transcripts of Mr. Rogers' trial?
I did not.
And do you recall the other mitigation specialists that were on the case before Mr. Giordano?
Cynthia O'Shea and Donna Murray.
Okay, one moment, Your Honor.
Yes, ma'am. Any redirect?
Yes, Your Honor.
Mr. Mummert, you watched some of Mr. Rogers' trial, is that correct?
Watched most of it.
You did? Was that in court?
No, I had it on in my office while I was doing like last minute trial prep for Mr. Sievers' case.
Okay, and you also sent some of your defense team to be there in the courtroom as well, if you recall.
I don't recall, but
Okay.
I recall I had a lot of time to myself with no interruptions, so that's likely.
Okay, but you do recall catching a majority of what was going on in his case?
Yes,
And his case was, his trial was prior to the trial in this case?
yes.
No further questions.
Anything further, defense? Is this witness to be released or retained?
We asked he be retained in case he needs to be recalled.
Mr. Mummert, you're subject to recall. We'll let you know if you're needed.
Let me go back to my office.
I would think you have his number,
Oh,
correct?
absolutely, absolutely.
I think you're good.
Thank
you. With that, why don't we take a 5-minute recess, let everyone stretch their legs, use the restroom if they'd like to, and 5-10 minutes. Should be enough time.
Mr. Sievers, can you hear from up here? Can you hear? I don't think that mic is on. No.
Tap it.
Yeah, it's on. Can you hear? I'll just ask him to speak.
Thank you very much.
State's ready.
Yes, Your Honor.
Defense is ready.
Yes, sir.
Next witness.
Next witness is Mr. Gregory Missouri.
I told her 30 or
Tomorrow?
30 tomorrow.
Okay.
I don't know what she took, but
It doesn't matter.
either one.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Hi, Judge.
Good morning, Mr. Missouri. Could you please state your name for the record?
Good morning, Gregory Jeremiah Masori.
And how are you currently employed at the moment?
I'm self-employed.
All right. Do you run your own law firm?
Yes,
How many years have you been an attorney in Florida?
1998.
And do you hold any other bar licenses?
Currently, no.
Okay. Did you used to hold any other bar licenses?
Yes, Massachusetts and federal court.
And prior to having your own law firm, where were you first employed? And if you could sort of walk us through your experience.
In Florida,
Yes, sir.
first I worked for Prudential Insurance, 1997 to 1998. When I moved from up north, then I got involved with the Public Defender's Office in Jacksonville. That's the 4th Judicial Circuit. And that was from 98 until about 2005. Went out into my own practice in Jacksonville until about 2009, and then returned to the Public Defender's Office until 2014 or 15, and then moved to Fort Myers.
And while you were at the public defender's office, what types of crimes did you handle?
All of them.
Okay. How many felony trials did you have while you were at the public defender's office, if you can recall?
Over 100.
And did you handle capital cases while you were at the public defender's office?
Yes.
How many?
While at the Public Defender's Office, probably 5, and then 1 in private practice.
So that would be about 6 total
Correct.
through to verdict?
Correct.
And in those capital cases, what roles did you have in those cases? Did you handle guilt phase or penalty phase?
Both.
And what were the results of your prior capital trials?
Well, all 6 were first-degree murder cases, of course. All 6 resulted in guilty verdicts at guilt phase. All went to the penalty phase. And 3 of those were life recommendations, and 3 were death recommendations, but 1 was overturned by the Florida Supreme Court.
And how long have you been death qualified?
Approximately 2005.
So at this point, almost 20 years.
Yes, but I have not been to the recent conferences that you need to go to maintain it, so I wouldn't say currently I am.
Okay. But at the time of Mr. Sievers' trial, you were death qualified.
Yes,
And you had attended the required continuing learning education seminars that are required to maintain the death qualification.
yes, either death is different or the other one, which escapes me right now.
Would that be life over death?
Correct.
Now, in your handling of death penalty cases, were the roles of the attorneys always bifurcated? And what I mean by that is one person handle guilt phase versus penalty phase?
To my recollection, yes.
And in your death cases, did you primarily handle penalty phase or guilt phase?
Both.
Both. Do you have a preference on guilt versus penalty phase?
In capital cases,
Yes, sir.
guilt.
Now, how did you become involved in Mr. Sievers' case?
After I had moved to Fort Myers, 2015, I believe, this case garnered a lot of media attention, and I was following it. And when I saw that the current defense lawyers on his case were having issues as far as their representation of Mr. Sievers, I contacted them and asked them if they might want to have a meeting and talk about my assisting them,
Okay.
which happened.
And do you recall roughly what year that was?
My best guess is 2017.
Thank you. And when you reached out to assist, who did you speak with?
Mr. Mike Mummert and his then partner, Tony Vega.
Okay. And did you meet with them in their office?
Yes.
Okay. And why was Mr. Mummert looking for a death qualified attorney?
I wouldn't say he was looking. I had reached out to them.
Okay. Were any of the lawyers involved in Mr. Sievers' case at that time death qualified?
No.
Now, at some point, did the court eventually file a court order allowing you onto this case?
Yes.
Were you paid for your work on this case?
No.
Now, what was your role supposed to be in this matter?
To assist Mr. Vega and Mr. Mummert in the case, and ultimately it would be penalty phase if it got to that point.
Okay. So your role was to be focused on the mitigation and the penalty phase presentation?
Yes.
Prior to this case, have you ever worked with Mr. Mummert?
No. Prior to this case,
Since this matter, have you
No.
worked with Mr. Mummert?
yes, we worked together on another murder case.
Okay. Did that case occur simultaneously with Mr. Sievers' case?
They were both going on at the same time.
Did that have an impact on your ability to work on Mr. Sievers' case?
I wouldn't say so, no.
And do you recall who was on the trial team for Mr. Mummert's office?
Well, Mr. Vega passed away during the pendency of this case. So Mr. Mummert was the only attorney. He had support staff.
Okay. Do you remember any of the names of the support staff?
Jen Mummert at the time. And no, I don't remember anyone else's name.
Now, as part of the trial team, were there frequent matters or frequent meetings or consultations with the trial team as to what to present for penalty phase or anything like that? Can you describe the dynamic?
Yeah, well, was your question frequent?
Yes.
And I'm not sure how to define that, but we had a number of meetings about the case, guilt and penalty.
Okay. And would you meet with Mr. Mummert in his office?
Initially, he and Mr. Vega had an office in Naples. I forget the road, main airport road. And then later on, Mr. Mummert had an office closer to downtown here. And I forget the name of the street. So we would meet there usually.
Okay. And were you provided the discovery in this case?
I would say a sizable portion of it. Not, I know I didn't receive all of it.
Okay. And how did you receive the discovery in this matter?
Hard copies as well as electronically.
Okay. Now, did you and Mr. Mummert collaborate and coordinate depositions?
They did all the coordination of the depositions.
Okay. Did you attend the depositions?
Some.
Okay. Was Mr. Mummert lead on this case?
Yes.
Did he consult with you as to what he needed to do to prepare for this case or pick your brain since you were the death qualified attorney?
I would say more pick my brain, but he handled almost all the majority of the preparation for it.
Okay. So he made the decisions as to who to depose,
Correct.
who to interview.
Correct.
Did he also make the decisions regarding what mitigation experts were used?
Yes.
Did you have any input as to which mitigation experts should be used?
No.
Not at all.
No. I was not familiar with the people down here who do this type of work as opposed to up north in Jacksonville. So I didn't have really any inkling of who you even go to down here for that kind of thing.
Okay. And is that because you were very recently moved to the area?
Yes.
Did you meet with the mitigation experts that were hired in this case?
Yes.
Do you recall who those mitigation experts were?
No.
Do you recall how many mitigation experts were involved in this case?
2, I believe.
Okay. Would the name Donna Murray ring a bell?
Yes.
Okay. Did you interact with her at all?
Yes.
Okay. Did you meet with Ms. Murray?
I don't recall face to face.
Okay.
It seems to me yes, but I don't recall.
Do you recall the name of the other mitigation investigator involved in the case?
No.
Would the name Jeffrey Giordano ring a bell?
I believe we discussed it in my deposition. I believe so, but I don't remember specifically.
Okay. Do you recall interacting with that last mitigation investigator and asking him to do things for the mitigation investigation?
We that was coordinated mainly through Mr. Mummert's office. The meetings were more as far as getting the witnesses aligned and who would be called and what they would testify to and what exhibits we might use.
Okay. Do you recall if those meetings were closer in time to trial?
Yes.
In the lead up to trial, did you have the opportunity to speak with any of the mitigation witnesses or interview them?
Yes.
And do you recall who you may have spoken to?
I'm not going to be good at any of the names because I'm just not good at names, but family members, brother, mother, stepmother, probably another brother, and I can't recall.
Did you meet with them in person or did you speak with them by phone?
In person.
Okay.
One of them maybe by phone because they were traveling, I think, from Missouri. But that person might have already been here in the days leading up to the penalty phase. So I'd like to say everyone was face to face. One could have been by phone.
Was that closer in time to trial or in the months leading up to trial?
Closer in time, I would say.
And did you have more than one meeting with these witnesses?
It's not all of them collectively, but some of them individually.
Now, in preparation for the trial, did Mr. Mummert consult with you regarding jury selection?
We discussed it. So if that's consultation, yes. But he was in charge as lead chair of the guilt phase. He was in charge of the jury selection.
Okay. Did you give him suggestions as to what sort of questions to ask?
I don't think I gave him a list or anything, but we had several discussions where we talked about the process.
Okay. Now, as part of the continuing learning education seminars that are given for death penalty attorneys, do those seminars go over jury selection?
Yes,
Do they give materials for jury selection?
yes.
Okay. Do you know if Mr. Mummert had access to those?
My recollection is that he did, and that he, I think, relied on them in putting in, not relied on them 100%, but certainly utilized them in putting together his jury selection.
And now, when you say you discussed jury selection with Mr. Mummert, did that include discussions regarding change of venue?
As I believe I testified earlier, I don't have specific recollections about change of venue, except my only recollection is that it seemed to me that he was collecting media reports, articles and such. This is my recollection on this, but I've done a lot of murder cases, but my recollection is he was collecting some of those items for potential use in it, but I don't recall where that went.
So you do not recall what the decision may have been regarding a change of venue motion?
I don't remember.
Would it be fair to say that you did not draft any of the motions that were filed in this case?
Drafted, I would say no, but I know I would have had input on some of them and probably reviewed them before they were filed, but drafted them, I would say no.
Now, obviously, you met with Mr. Sievers during the course of your representation in this case.
Yes.
How often did you meet with him?
I don't recall. Obviously, they all would have had to been at the jail, unless we, spoke in court or, in a private room or something. But, gee, I don't know. 6,
6 times?
perhaps.
And do you recall discussing what was needed for the penalty phase with Mr. Sievers?
What was needed? I'm not sure I understand that question.
Did you talk to him about the penalty phase and explain it to him?
Yes.
Okay. Did you ask him to provide input regarding the mitigation case?
Once again, I'm not certain what you mean by that, but the process was discussed, and everything that happens during that phase, if it gets there, was discussed. I know we spoke about his daughters at one point, and we decided we weren't going to call them as witnesses.
Now, regarding the penalty phase, did you and Mummert have a theme for the penalty phase?
Once again, I'm not sure about the question as far as a theme, but we certainly had a direction we planned to go.
And what direction did you want to go with the penalty phase?
That would be mostly highlighting Mr. Sievers' positive qualities and traits, of which there were many. Probably number one being his exceptional role as a father.
And was that a decision you and Mr. Mummert came to?
Yes.
And did you have the opportunity leading up to trial to review documents and information gathered for mitigation by the various investigators that Mr. Mummert had?
Yes.
Did you ever make suggestions to the investigators as to what information or further information you needed for the penalty phase?
I don't remember not having anything that I was interested in using.
During the mitigation investigation, did you happen to travel to Missouri or have an investigator do so?
I did not travel to Missouri. I think Mr. Mummert did conduct depositions at some point, but I didn't go to Missouri, and I don't know who else went to Missouri.
Did you try to have Mr. Mummert's investigators obtain information regarding any prior head injuries or any school records or anything of that nature for Mr. Sievers?
Head injuries, I don't recall anything on that. School records, I specifically don't recall either. Yeah, I'm sorry, I don't recall.
Do you recall if there were any experts consulted for the penalty phase in Mr. Sievers' case?
There was a mental health expert consultant.
Okay. Did you speak with that mental health expert?
I can't recall.
Ultimately, was that expert used in penalty phase?
No.
Did you recommend any doctors or anything to Mr. Mummert for the penalty phase that you knew of from your prior experience?
No.
And did Mr. Mummert make all of the selections of any experts that were used in the case in both phases?
Yes.
Was there ever a presentation created for penalty phase to describe Mr. Sievers' childhood and family life?
A presentation?
A presentation or a PowerPoint?
My recollection is there was.
Okay. Do you know who created that?
I think that was a collaborative effort amongst his support staff. And then we would review it and move things around and adjust things.
Was that presentation used at trial?
That's my recollection is it was.
Do you have a clear recollection of that, or would the record reflect whether that occurred?
The record would reflect. I've used them in several other death penalty cases, and unfortunately, after 7 of them, they kind of merged together.
And you don't have a clear recollection as to who may have contributed to that PowerPoint presentation or had input on it?
Well, I know that someone in his office, and I can't remember if it was his wife at the time or someone else. I think they had somebody who was very strong with computers, a younger person who was knowledgeable about that stuff, which I am not.
Now, previously you testified that there was more than one mitigation investigator involved in this case. Do you know why there was a switch in mitigation investigators?
Specifically, I don't recall. I do know that there was a breakdown in the communication or in the relationship that led to the replacement of the woman.
Would that have been Miss Donna Murray?
I believe that name sounds familiar.
Had you ever worked with Donna Murray prior to this case?
No,
And you don't know why the communication broke down?
I don't remember, no.
Were there ever discussions between yourself and Mr. Mummert about filing a motion to continue in this case?
This case was, I don't know how many times it was formally continued, but obviously the case took a long time to reach trial. So I can't comment on the number of continuances or who moved for what when.
If I may have a moment, Your Honor.
Yes, ma'am.
Now, all the records in Mr. Sievers' case, discovery, mitigation items, were all of those located at Mr. Mummert's office?
Yes,
Would you have to go over to Mr. Mummert's office to view these items, or would they email them to you?
both.
Both? Did you spend a lot of time at Mr. Mummert's office reviewing all the documents?
No, I think I had access on my own to everything that I wanted to review or needed to review. I prefer things in hard copy because I'm old fashioned that way. But if things had to be viewed on computer, I'd do it that way too.
In your prior cases where you conducted penalty phase, were those when you were with the public defender's office?
I believe 5 out of 6 were.
Okay. So with the public defender's office, there's a lot of support, investigative staff, is that correct?
Yes.
Okay. Did you feel you had the necessary support and staff for this penalty phase?
Given the way that this penalty phase was going to play out, yes.
I'll pass the witness at this point.
Steve?
So, Mr. Masora, you had access to all the discovery in this case, right?
Like I said, I didn't review every single shred of discovery. Certainly all the things with cell phones and that stuff. I didn't spend much time on that, but I had access to it, yeah.
There was a lot of stuff, wasn't there?
Yes.
Tens of thousands of pages of discovery, right?
I wouldn't doubt that.
And gigabytes of data on hard drives and disks, maybe even terabytes, right?
Whatever those are,
Whatever
yeah.
that is.
Yeah, probably.
And you were able to see everything you needed to see in order to prepare mitigation, right?
I felt so.
And let's talk a little bit more about your history. You have a Juris Doctor degree, right?
Yes.
From which university?
University of New Hampshire?
And you also have an LLM, right?
Yes.
And where's that from?
University of San Diego?
And what is the LLM in?
Concentration in criminal law?
So you and I both have JDs. Mine's from University of Florida. What's the difference between a JD and an LLM?
JD is the 3-year regular law school curriculum, and the LLM is a 1-year graduate program after law school.
So an LLM is something that goes above and beyond what you learn in law school and get your JD.
It's a master's degree, yes.
Mr. Mummert also had the services of Al Olson and Marie Olson, their private investigative firm, at his disposal, right?
I'd forgotten their names also, but yes.
And
Al. I remember Al.
you remember Al?
Yeah.
And Mr. Mummert also had the services of Jennifer Wood or Jennifer Mummert as part of the team as well, right?
Yes.
She was very active in the defense team, right?
Yes.
And it's safe to say that based on your experience and the training, you got a very good idea of what's needed in order to properly present a mitigation case, correct?
Yes.
And did you have everything? In fact, you had everything you needed in order to present your mitigation in this case, correct?
I felt so.
And despite the fact that a change of venue was never, a motion for a change of venue was never filed and venue was never in fact changed, Mr. Mummert did the research on the change of venue, right?
That's my recollection.
And as an attorney, have you often, in fact, as a trial lawyer, you've often researched different avenues, different defenses for your client, right?
Yes.
And then you make a tactical decision of whether or not to use that defense or that information, or a tactical decision not to use it, right?
Yes.
And this was a tactical decision not to change venue at this time, right?
Once again, I'm going to leave that to whatever the record reflects. I don't recall what surrounded that.
Okay.
Typically, I've never moved for a change of venue personally, but I know that during my course of time, the U.S. Supreme Court and then other courts found that usually you have to try to pick a jury. In the old days, you could move for change of venue and show a bunch of news articles, and the judge would say, "Okay, we're moving it." But I believe now you have to at least attempt to pick a jury first, and then if problems arise, then you look at venue change.
Okay. And we were able to pick a jury here in Lee County during State versus Sievers, right?
We did pick a jury, yes.
And you were involved in jury selection, isn't that correct?
Yes.
You were present at the defense table with Mr. Mummert and Mr. Sievers.
Yes.
You were able to give insight and advice on jurors that were being selected or talked about during your process, right?
Yes, we went over all the potential jurors before they were selected.
And Mr. Sievers and Mr. Mummert were able to listen to you and talk to you during that process, right?
Yes.
And in fact, Mr. Sievers was involved in the jury selection process as well, wasn't he?
Well, he was certainly here every day for it, yeah.
And if he didn't like a juror or didn't think a juror should be on his jury, he was able to tell you and Mr. Mummert that, correct?
We all kept notes on the various jurors.
In fact, Mr. Sievers took copious notes during the process, didn't he?
He took a good amount of notes, yes.
And despite the fact that you volunteered to be on the Sievers team, Mr. Sievers didn't in fact hire you, right?
No.
He hired Mr. Mummert.
Yes, and Mr. Fega.
And Mr. Mummert and Mr. Mummert, at least after Mr. Fega passed away, Mr. Mummert was lead counsel, right?
Correct.
And Mr. Sievers was okay with that.
He seemed to be, yes.
You were okay with that.
Yes.
You also, along with Mr. Mummert, made tactical decisions on what to present and what not to present during mitigation, right?
Yes.
Such as the daughters.
Yes.
Now, unlike some of the other clients you've represented in death penalty proceedings, there were some things about Mr. Sievers that were different, right?
Yes.
He's got a high school degree, right?
I thought he had a college degree too.
Got a college degree, correct, right?
Mhm.
Didn't suffer from any known maladies such as substance abuse, alcohol abuse, right?
Not that I knew of.
Had no obvious mental deficiencies or physical deficiencies, right?
No, he's a very bright man.
So how did Mr. Sievers, those things about Mr. Sievers affect the choices that you made in mitigation?
He did not present as a damaged, broken human being, but as a generally upstanding member of the community. So that was the way we presented it.
So your mitigation case for Mr. Sievers was to present him as an upstanding father, an upstanding member of the Lee County community, correct?
Basically.
And other mitigations, you have clients who you present as broken individuals, right?
Yes.
They're mentally ill, they have substance abuse problems, they come from broken homes, things like that, right?
Yes.
Mr. Sievers' situation was different, isn't that correct?
Well, his parents had been divorced, but he certainly had loving parents and a support system.
And you were able to execute your mitigation plan to your liking, isn't that correct?
Yeah, probably except for the daughters. Of course, hindsight's 2020, but given the outcome, maybe one or two of the daughters should have taken the stand. But I don't think Mr. Sievers wanted them to, and it was a lot to put. They were very young at the time. It was a lot to put two young kids through, and that decision was made.
And in fact, during the sentencing process, didn't a letter from one of the daughters kind of pop up during the PSI process?
Is that I don't recall when it popped up, but and I couldn't recall if it was a postcard or a letter. But yeah, yes, something did arise, and it was entered, I believe, into evidence.
So even though you made a tactical decision not to call the daughters into court, that letter from one of the daughters still was able to be entered into evidence and made available to the court during the sentencing process, right?
Yes, and whether that was the penalty phase or the Spencer hearing, I don't recall.
So during the process of defending a client, isn't it the lead attorney who bears the responsibility for ultimately making tactical decisions in the case, whether they're made or not made?
Yes.
Do the mitigation experts, especially the ones that aren't members of the bar, have responsibility for making tactical decisions?
No.
Do the mitigation experts have the ability to legally tell the, I guess, let me ask a better question. Does a mitigation expert's judgment over how to defend a client supplant the judgment of a member of the bar?
No.
And you said earlier that this case took a long time to go to trial. Was there enough time to prepare a defense in this case?
I would say yes. We went to trial, I believe it was next month. I think it'll be 6 years, November, I think it was. And the whole thing started in 2015. Mr. Sievers, I believe, was arrested in early 2016. There were a lot of discovery issues as far as getting things delivered to the defense. And I know that some computers were hard to read or something. And it was a big mess with all that. But ultimately, 3.5 years or whatever later, it appeared to be ready for trial.
And even though Mr. Mummert was lead counsel, if you as co-counsel felt that this case was not ready for trial, if you needed more time, would you have availed yourself of your ethical obligation to come in here and tell the court that you needed more time?
Yes.
And you didn't need to do that, right?
No.
Okay. I apologize, Your Honor. I had a brief conference with co-counsel. And despite the fact that or in addition to the fact that the letter from the daughter came in, you were also able to secure mitigation testimony from Sievers' family members about his role in his daughter's lives, right?
Yes.
The jury was able to understand his role as their caretaker, right?
Yes.
While Dr. Sievers was the breadwinner.
The primary breadwinner, yeah.
Primary breadwinner. And you also were able to produce testimony of not only the fact that he was their caretaker, but he was their loving caretaker, right?
Yes.
And in fact, you were able to secure testimony that his daughters wanted to maintain a relationship with him, despite the allegations against him, right?
Yes.
I'll just ask this question. I asked it in your deposition. I think it's fair to ask it now. Trial lawyer to trial lawyer. Is there anything you would have done differently?
In retrospect, except for the daughters, I can't think of anything.
All right, thank you.
Defense.
Just briefly, Your Honor.
Now, Mr. Missouri, even though you primarily worked on penalty phase, you also reviewed much of the guilt phase evidence. Is that correct?
I would say a lot of it.
Okay. And you also reviewed Mr. Jimmy Rogers' case.
Reviewed it. I monitored it.
Okay. You monitored it. You were aware of the state's presentation in that matter.
Like I said, I monitored it. I wasn't glued to it.
Would you say that case had a lot of similarities to Mr. Sievers' case?
I thought it did, yes.
Okay. And that it was important to monitor for the investigation of both of the guilt phase as well, correct?
I'm sorry?
It was important to monitor for preparation for the guilt phase, correct?
Oh, it definitely would have been, yeah.
Due to the similarities.
Correct.
No further questions, Your Honor.
State.
Nothing further.
This witness to be released or retained.
Release, Your Honor.
Agree? State?
Agreed, Your Honor.
Thank you. You're free to go.
Thank you, Judge. Good luck, Mark.
Defense.
Your Honor, that is our last witness we have for the morning. Our next witness we should be here this afternoon.
What time? 1:30?
I believe we told them 12:30.
When do you guys want to come back? 12:30 or 1?
I'm looking at Madam Clerk,
Oh,
so I'm wondering when she
we don't
wants to
have-
come back.
We don't have anything else this afternoon. You guys are it, so it doesn't matter.
Judge, I think 1 o'clock is a good time. Give
1 o'clock?
everybody a chance to get a bite and come back.
Yeah, the only thing I have this week other than this is this morning I was assigned 2 cases that need a pretrial detention hearing, which will be tomorrow at 8:30. But they shouldn't take long.
That's fine, Your Honor. And in full candor for the court, we did have a few witnesses this morning that had some travel issues, so we had planned for them to testify this afternoon, but they will be here tomorrow. So we have the 1 witness this afternoon, and that's all we have for today.
You only have 1 for today?
Yeah.
We'll still be on track to wrap it up this week though, correct?
Yes,
Absolutely.
honestly,
Okay.
Depending on how long your pretrial detention takes and the flow of the witnesses, I don't want to speak too broadly, but I think we can finish by Wednesday.
Okay.
At least
Just want to
for
make sure we're on
defense phase.
track.
Yeah, we are on track, absolutely.
Who's your next witness?
Our next witness is Donna Murray.
Okay. All right. Well, we'll see everybody at 1 o'clock.
Thank you, Your Honor.
Yes, ma'am. Maybe we should start within the 9.
All right, brother, see you in a bit.
Before we go on record, I'll make sure the defense is ready with his hearing.
Thank you, Your Honor.
Yeah, I think we're good to go.
Okay. For the record, Mr. Sievers is present, his 3 attorneys are present, and both representatives of the state. The state's ready to proceed.
Yes, Your Honor.
Defense is ready to proceed.
Yes, Your Honor.
Next witness.
Donna Murray.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Good afternoon.
Chair doesn't want to roll. Could you please state your name for the record, please?
Donna Murray.
And how are you currently employed?
I'm a mitigation specialist. I have my own investigative agency.
Okay. And how did you become involved as a mitigation specialist? Excuse me.
I was working at the Public Defender's Office, working in their capital crimes division as chief investigator, and started doing mitigation, but felt like I wanted to do more than what I could do through the office. And so I branched out on my own.
Okay. And when did you work at the Public Defender's Office?
2007 to 2013.
Okay. And once you branched out, who did you work with?
I initially started working with an attorney, Cindy O'Shea, who had her own mitigation office. And after a couple of years of working with her, then I branched out and I started my own agency.
Okay. And when did you start your own agency?
8.5 years ago, I'm proud to say, 2017.
Congratulations.
Thanks.
How many mitigation investigations have you participated or conducted over that time period?
Probably more than 70.
Okay. And that would include with the Public Defender's Office and with Cindy O'Shea?
Correct.
May I approach the witness, Your Honor?
You may.
Thank you. showing the witness what's been marked, pre-marked Defense Exhibit 1. Do you recognize that?
Yes, I do.
And is that your current curriculum usage?
It is.
And is that a current and accurate copy of that curriculum usage?
It looks like it is, yes.
At this time, we enter evidence.
Objection, Your Honor. We object to hearsay. We're more than happy to have Ms. Murray testify as to her expertise, but the CV itself would be hearsay.
Sustain. Do you yield to her as an expert?
Yes, Your Honor.
Okay. But if you'd like to go through her educational record and everything else, you may do so, defense.
Thank you, Your Honor. What is your educational background, Ms. Murray?
I have a bachelor's degree from the University of South Florida in criminal justice, and I have a master's in criminal justice administration through the University of South Florida.
And what licensures or certifications do you hold?
I'm a licensed private investigator. I also have a notary. I've been certified in several different courses that I've taken over the years in investigations and mitigation.
Okay.
Fundamentals of mitigation is one of them.
And you have attended several mitigation presentations as part of your continuing education?
Yes, I've been to many conferences over the years.
And have you also presented at mitigation presentations as a guest speaker?
Yes, I have.
Okay. And how many courses have you attended over the years for capital mitigation in your training?
A lot, hundreds of hours. I couldn't give you an exact number,
Okay.
but many hours.
All right. And you currently still work as a capital mitigation investigator?
Yes, I do.
And how did you first become involved in Mr. Sievers' case?
I received a phone call from his attorney's office asking me if I would be interested back in, I think, like September of whatever year it was, 2018.
Okay. And was there any follow-up after that phone call?
The follow-up came from a colleague in Miami who happened to be scrolling through the court docket and called me to tell me that she was surprised that I was on Mr. Sievers' case.
Were you aware at that point that you had been hired or appointed to Mr. Sievers' case?
I was not.
Okay. And the court order that your colleague alerted you to, what was that order, if you recall?
An order appointing me as mitigation specialist.
After you discovered that order, what did you do?
I contacted the office to ask them what was going on. I had another jail visit at the jail that week, so I called and said, I'm going to be there anyway. I'd like to go meet the client.
Okay. And who did you speak with at that time?
I thought it was an attorney, but it was the lady that was the administrator, Ms. Wood.
Okay. Jennifer Wood?
Yes.
Okay. But at the time, did you know what her role in that office was?
No,
Okay. And I believe you stated that you thought she was an attorney?
I did.
Did you ever speak with Mr. Mummert in the initial stages of your involvement in this case?
No.
Were you aware that there had been another mitigation investigator involved in this case?
I was, after I got involved with this one, I was sent a couple of interview notes from the prior mitigation specialist.
And who was the prior mitigation specialist?
Cynthia O'Shea.
Now, did you have an opportunity to speak with Mr. Sievers?
Yes, I met with him at the jail one time.
And was he forthcoming with mitigation information at that time?
He was very pleasant and cooperative. He answered all my questions.
Now, did you receive any records from the trial team?
No, I was sent a Dropbox link, but it was empty. There was nothing in it. And I did go to one meeting in their office and I was shown a room that had lots of banker boxes in it, but I wasn't actually provided with much of anything.
Okay. Did you meet often with the trial team to discuss what the mitigation would be, what direction they were heading?
I met with Miss Wood and an investigator one time in their office. There were no attorneys present, and I never met with anybody else.
And do you recall the name of the investigator?
I do not, sorry.
Now, after you met with Mr. Sievers, did you attempt to interview any witnesses or start the process of doing interviews for the mitigation investigation?
What I did was I contacted the office because they told me that there was going to be a trial scheduled, and I asked them to file a continuance because there was no way I would be able to conduct a mitigation investigation in just like the 3 months or so that was set aside for me. And I was supposed to go to visit Missouri to go find to interview some witnesses there. And I asked for a trial order, but before I would, or a travel order rather, and before I would do that, I wanted to make sure that I was going to have time to get all this done. And they were adamant that the case was going for trial. They were not going to file a continuance. And I felt like I wouldn't have enough time to really get anything accomplished.
And why did you feel that that was an insufficient amount of time to handle a mitigation investigation?
Well, first of all, based on the ABA guidelines, you have to do a thorough investigation.
Sustained.
Sorry. Based on my experience and my training, you have to have sufficient time to accomplish an entire life history. And 2 or 3 months is not enough time to find every person that's ever met the client, gather all the records that are required, review them, and then get experts to potentially testify about some of the issues that you find.
Were you aware that some of the records you would need were already gathered by Ms. Wood?
I saw one box that had some photographs in it, but I didn't know of any actual records that were related to the client.
Okay. Did you ask or request to see any documents relating to the client?
Well, I wanted to get some of the discovery so I could find out basically what the charge was and why he was in custody in the first place, but I never received anything.
And what efforts did you make to contact the trial team and try to get this information? Was it just by phone or via email?
I sent several emails, most of which were not responded to.
Okay. Now, as part of your business, do you also fully document your interactions with trial teams in case there are any problems?
Yes,
And that's just part of the normal business to keep notes on everything?
standard procedure for me anyway. I try to keep track of everything that I'm doing in a case.
Okay. And is it also as part of your experience, do you raise concerns regarding problems with mitigation or issues you may be having with witnesses?
Yes.
Now, in the past, when you have raised issues regarding timings, how have lawyers responded to those requests for more time?
Generally, they accommodate my requests. They recognize that there's not enough time to get things done, and they'll file a motion for continuance.
Okay. Now, in your discussions with Mr. Sievers' team, did it appear that they were very savvy or knew a lot about death penalty or mitigation?
Objection, Your Honor, outside the scope.
Sustained.
Did you have conversations regarding their prior experience with mitigation?
Ms. Wood sent me an email that said that she wasn't familiar with how mitigation is done.
Now, did you, via email, express your concerns regarding this case?
Yes,
And you made several attempts to communicate with the trial team via email?
I did.
Okay. And those emails were sent to Miss Wood.
Correct.
Were they also sent to Mr. Mummert?
Yeah, I believe I copied Mr. Mummer and then Mr. Massour.
Okay. If I may have a moment, Your Honor.
Ma'am. Those
At
are
this
marked.
time, showing what is being pre-marked as defense exhibit 2 to the witness. Do you recognize that?
I do.
And how do you recognize them?
There are copies of emails that I sent to Mr. Mummert's office.
Okay. And those also include your emails to Ms. Wood?
Yes,
And is that the sum total of your correspondence with Mr. Mummert's office regarding Sievers, the Sievers case?
I would say yes.
And that is the sum total also of your communications with them, including your history of the case?
Right.
Your Honor, at this time, I would like to move into evidence what has been pre-marked as defense exhibit 2.
Objection hearsay.
And both sides approach. We'll give the defense a moment. And the objection sustained for the record at this time. I'm too close to the mic.
Is that you, Buzz?
I think so. Steer clear of it, then we'll see.
You want to use this one?
You've had enough time to talk to Mr. Sievers?
Yes, Your Honor.
Yes, Your Honor.
Excellent.
Now, Ms. Murray, the emails you sent to Mr. Mummert's office and to Ms. Wood contain the history of what you have explained to the court here as your participation in Mr. Sievers' case.
Yes.
They also contain your concerns regarding the amount of time you needed for the mitigation investigation.
Yes.
Okay. And these emails also describe their lack of communication with you throughout your participation in this case.
Yes.
Were you aware of any efforts made by the team to hire mitigation experts such as a psychologist?
I don't believe they did.
Did they ever convey to you that they attempted to do so?
No.
Would that have been an important piece of information for the mitigation investigation for you?
Absolutely.
And you were never made aware of any possible reports or information they conveyed?
No.
In your expertise, do you also assist trial counsel with not just the gathering of mitigation and information, but also suggest or recommend experts based on what you have discovered through your investigations?
Yes, that's standard procedure for me to decide if certain experts would be appropriate or helpful and then make recommendations to the team.
Okay. And ultimately, it would be up to trial counsel to either accept or reject that recommendation?
Right.
Did you have the opportunity to do that in this case?
I believe I did.
Okay. Ultimately, once you expressed concerns to the trial team, what happened after that?
A couple of emails went back and forth, and I basically told them that I wouldn't work on the case and I guess resigned from it.
Okay. And that was due to the lack of communication?
Correct.
And the fact that you felt you could not complete the work in a timely manner?
Correct.
At this time, I'll pass the witness.
State.
Hello.
Hi, Ms. Murray. My name is Christina Pacheco, and I'm going to be asking questions for the state.
Okay.
Ms. Murray, you had another capital case pending when you were retained for the Sievers case. Is that correct?
I'm sure I did.
Okay. And you mentioned that your friend was surprised that you were on the Sievers case?
Right.
You're not a lawyer, are you?
No.
And you talked about the room in Mr. Mummert's office that had a bunch of boxes in it.
Right.
Did you ever look through any of the boxes?
Ms. Wood showed me one of the boxes that had pictures in it. But from my understanding, all of the other boxes were first phase documentation.
Okay, but you were offered access to these documents.
Yes.
You mentioned that you would have liked to have been made aware of the indictment and the charges. Presumably, if there were a bunch of boxes that were first phase, those would have been in the boxes?
I would assume so.
Okay, so you had the ability to look through the boxes?
Yes.
Okay, and you didn't make an appointment to do so?
No. What I did was ask for a Dropbox link, and I was supposed to have them sent to me.
Okay, and there was some sort of miscommunication with the link, either it was sent or it was sent empty, is that correct?
Right.
Did you follow up once you were not able to open the link or obtain the documents and tell them that the link was not active?
I sent an email.
Okay, did you call the office?
I don't think so.
Okay. You mentioned that you did meet with Mr. Sievers one time.
Correct.
And after that meeting, did you conduct any sort of investigation into the mitigation in this case?
No, I contacted the office and told them that I needed more time to do it because I learned that some of the some of the witnesses were out of state and there would have been more work to do. And I didn't feel like I had the time.
So knowing that time was of the essence, did you attempt to start some of the investigation?
Other than reviewing what I did have, some of the prior interviews that were done by the person that had the case before me, Ms. O'Shea, and meeting with Mr. Sievers, no.
But you didn't conduct any additional investigation?
Correct.
Did you want to be on this case?
Sure, yeah.
You did?
I don't like to say no to cases.
Okay. May I have a moment to confer?
Yes, ma'am.
And just to clarify, nobody impeded your access to the files in Mr. Mummert's office, did they?
No, I wouldn't say that.
And despite your admission here today that you wanted to be on the case, you didn't actively pursue investigation in this case.
I wanted to be on a case with death qualified attorneys, and I was learning quickly that they were not.
No further questions. Thank you.
Defense.
No further questions, Your Honor.
Is this witness to be released or retained? Agree?
Yes, Your Honor.
Thank you, ma'am. You're
Thank
free
you.
to go.
Thank you.
That's it till tomorrow, is that correct?
That's correct, Your Honor.
Okay. My two pretrial detention hearings should be pretty quick, but the abundance of caution, we'll have everyone come back at 9 o'clock. It'll definitely be done by then.
Judge, may we have a moment with counsel?
Absolutely.
And actually, we will probably have some just administrative stuff amongst ourselves that we need to discuss.
Okay.
Yeah.
You guys need a recess or?
Before we retire, I actually had a housekeeping matter to address with Your Honor, if that's okay.
What, do you guys need a moment to speak alone or are we going right to it?
I did talk to them about the judicial.
Yeah.
Are you okay?
Oh, yes.
Okay. Your Honor, if we would like to request, we haven't filed anything in writing, but just orally request that this court take judicial notice of its own court file in this case, so we can refer back to the trial.
It's no problem. I was actually going to do that and forgot to do it first thing this morning. I'll take judicial notice of the case file, all its contents and records.
Thank you, Your Honor. And we would also ask for judicial notice of Mr. Rogers' case file, given that they were traveling together.
Take judicial notice of that file as well and all its contents.
Thank you.
Just one other issue that I discussed with counsel. One of the witnesses, I saw her outside before it's 1:30.
Well, if you guys,
We're not ready to put that person on the stand, Your Honor. to be
Okay.
Completely candid, and I resent that Mr. Hunter here is trying to run our case. Please.
okay. Well, I mean, if you guys wanted to wait a couple hours and then call them, that's fine. You want to wait till tomorrow, that's fine by me too. We got all week. Tomorrow then?
Yeah.
Okay. See everybody at 9.
Thank you.
Thank you.
Your Honor.
Deputies bring Mr. Rogers for tomorrow.
Okay.
That's what they told me.
Already done.
Afternoon.
Afternoon. yeah.
They're good. They already got it taken care of.
Thank you.
Thank you.
He's done, but he's gonna talk to the attorney.